Hey, folks, welcome to today's episode of the Law of Self-Defense Show. I am, of course, Attorney Andrew Branca for Law of Self-Defense. Thank you very much. And today, wow, that's amazing. Thank you so much. So much appreciated. And today I wanted to share with you a blog post I actually wrote a couple of days ago for the website Legal Insurrection that's run out of Cornell Law School, a legal/political blog that I write for, and I'm proud to write for from time to time whenever they'll have me, about the Breonna Taylor case. And we'll go through the facts of the Breonna Taylor case. In quick overview, she was a young Black woman in the company of an apparent drug dealer when her apartment was subject to a search warrant by police. She was standing next to a young Black male who's been characterized as her boyfriend. When the police entered the home, the boyfriend shot at the police with a handgun. The police returned fire with their rifles, and Breonna Taylor was struck, unintentionally struck and killed by the police fire. So that's a quick overview. All that happened a couple of years ago. One of the officers, not one of the ones who fired a shot at Breonna Taylor, so not the officer who actually killed Breonna Taylor, one of the officers involved in the service of the search warrant was charged at the state level for essentially reckless endangerment, for having fired his gun, the state would argue, blindly into the apartment through Breonna Taylor's apartment into an adjacent apartment where innocent bystanders were present and endangered by his fire. He would be acquitted of the state charges. No other officers were charged, and until last week. So last Thursday on August 4th, 2022, the Federal Department of Justice brought civil rights charges against 4 of the officers involved in the search warrant of Breonna Taylor's apartment. Now, only one of these 4 officers was actually at the scene where Breonna Taylor was shot. That was the officer who's already been tried in state court on reckless endangerment charges and acquitted. The other 3 officers charged by the Department of Justice last week in the death of Breonna Taylor were involved in the preparation of the search warrant. And they've been charged under, all 4 of these officers now have been charged, indicted by a federal grand jury on charges that carry the death penalty as a possible punishment. So about as serious as charges possibly get, 2 years after the event. And one wonders about this delay, frankly, because it's not like new evidence was really developed over the last 2 years. But in any case, what I wanted to talk about today was these indictments. So we have copies of the indictments. For those of you who are Law of Self-Defense members, you'll find today's show in blog form on the Law of Self-Defense website, lawofselfdefense.com/blog. And I will also include in that blog post not only today's video, but also links to the indictments, links to my prior coverage, other prior coverage of this events surrounding Breonna Taylor's death, so you can have a more comprehensive view. In this video, I'll be making reference to the indictments, but I'm not going to pull them up on the screen. It's too unwieldy to read live on stream the clunky terminology of these grand jury indictments. But I'll share with you the relevant content of the indictments and talk about that in the context of each of the 4 officers charged. I will say, before I dive into the show proper, that I see a number of commentators on YouTube, lawyer tubers, whatever we're calling folks these days who do this, legal commentary on YouTube, who are characterizing the death of Breonna Taylor as a murder. That, for example, these federal indictments, grand jury indictments, have evidence of a murder, or are charging a murder, or the indictments are for murder. No one in any position of authority has ever claimed that Breonna Taylor was murdered in the proper meaning of the word murder. I mean, words matter. What they mean matters, right? Murder being the intentional, premeditated killing of another human being. Everyone acknowledges that Breonna Taylor's death was unintentional. The officers were not intending to shoot her. She was an innocent bystander. in this event. So there was no murder here. Nobody's ever been charged with murder. The one officer charged in state court was not charged with murder. He was not charged with any use of force against Breonna Taylor. None of the other 3 officers indicted by the federal grand jury were even on the scene. So they didn't murder her. They used no force against anybody involved in this event. So there is no murder here. Anybody you hear talking about the murder of Breonna Taylor either has a political agenda or they don't know what they're talking about, because there was no murder. Now, might there be a criminal liability for a reckless killing? That's the argument I imagine the DOJ is fundamentally making, saying that their general claims are things like these other officers, the 3 officers involved with the preparation of the search warrant, lied in the preparation of the search warrant, then conspired to cover up the lie, and collectively this misconduct in that part. They knew the warrant would be served by armed officers. They knew there was a danger, therefore, of harm to innocents. And so somehow they bear criminal liability for the death of Breonna Taylor. If they do, though, it would be at worst recklessness. I mean, none of them had any intent towards Breonna Taylor. I expect they had no reason to believe Breonna Taylor would be involved in anything other than the fact that it happened to be her apartment where they had good reason to believe drugs were being sold. But what I'd like to do is step through so there's 3 grand jury indictments here. One for the officer who's already been tried in state court and acquitted on reckless endangerment charges. A second for one of the officers involved in preparation of the search warrant. And then a third that indicts 2 additional officers also involved in preparation of the search warrant. So we'll step through each of those indictments in the context of each of the officers involved, and I'll share with you my thoughts on all of that. Of course, as always, we should have a sponsor of today's show, and that sponsor is no other than Law of Self-Defense itself. So let me pull up our sponsor page here. There we go. And the sponsor is Law of Self-Defense, where you can get a copy of our best-selling book, The Law of Self-Defense Principles, a real book, folks, real physical book, not some grifty PDF download, a couple hundred pages. I urge you to look up the book on Amazon. It's got over 1,000 reviews, 5-star rated. If any of you who are watching this on YouTube in particular have read the book and enjoyed it, feel free to say so in the comments so people will know I'm not just making this up. But there's also all the reviews on Amazon. But I urge you not to buy it on Amazon. If you buy it on Amazon, they charge you $25 plus shipping and handling. I will give you the book for free, meaning I'll eat the cost of the book. We do still ask that you cover the cost of us shipping the book to you. So there is a modest shipping and handling fee, but there is no $25 charge for the book. So if you'd like a free copy of this best-selling book on the law of self-defense, it's very easy to read. It's written in plain English. Most people get through the book in about 3 hours, an afternoon, casual afternoon of reading. Then I urge you to take advantage of this opportunity to get your free copy of this book, The Law of Self-Defense Principles, at lawofselfdefense.com/principles. Sorry, that's the name of the book. At lawofselfdefense.com/free book. That's where you want to go. lawofselfdefense.com/free book. All right. So that's the sponsorship obligation out of the way. And let me start now with the actual substantive content of today's show after a sip of coffee from our wonderful Law of Self-Defense mug. Law of Self-Defense, be hard to kill and hard to convict. By the way, if you'd like one of these mugs, you can get this at lawofselfdefense.com/mug as well. All right, so let's dive in. So I'm going to, I still have a new computer, so a lot of this is a little prep worthy, but let's go ahead and get started with the Department of Justice federal grand jury indictments of 4 officers in the 2-year-ago death of Breonna Taylor. So this past Thursday, August 4th, the United States Attorney General Merrick Garland announced charges against 4 Kentucky, these would be Louisville Metro Police Department officers, for various crimes around a search warrant for the apartment of a young black woman, Breonna Taylor. The officers charged are Officer Brett Hankison. He's the officer who's been previously charged in state court for essentially reckless endangerment and acquitted. Detective Kelly Goodlett, Detective Joshua Janes, and Sergeant Kyle Meany. Now, notably, all four of the officers indicted here are subject to execution, capital punishment, death, if found guilty on the most serious of the charges specified in these indictments. And those would be the charges alleging violations of federal code 18 USC section 242. A violation of section 242 that results in death carries as a possible punishment execution. And many of the other counts on which they've been indicted, other alleged violations of federal code, are good for 20 years in prison. So all of these officers, thanks to these grand jury indictments, are now facing charges that would put them in prison for much of the rest of their lives, probably the rest of their lives, or execution. It doesn't get much more serious than that, folks. I also note when I read these indictments how heavily they are relying on undocumented, meaning there's no documentation of the claims they're making, there's no records, undocumented and ambiguous assertions of the evidence that the indictments claim support these charges. And this is particularly odd given the severity of the charges and the punishment, death, that these charges carry. So the search warrant in question was served on Breonna Taylor's apartment during the early morning hours of March 13th, 2020, so more than 2 years ago, about 1 o'clock in the morning, and they were directed at a criminal target who all identified by their initials, JG, who was a purported drug dealer. And the authorities, the police, believed he was dealing drugs, receiving packages, money at Breonna Taylor's apartment. So using Breonna Taylor's apartment to facilitate his drug enterprise. During entry of Breonna Taylor's apartment, the officers making the entry, and Brett Hankison, one of the four officers just indicted, but not the other three. The other three officers just indicted by the federal grand jury were not involved in the service of the search warrant. But one of them, Brett Hankison, was standing outside the apartment. Other officers were going in. As they went in, they were shot at by Breonna Taylor's boyfriend, Kenneth Walker, who fired his handgun at the officers as they entered Taylor's residence. One of the entering officers was struck and severely wounded in the leg by Kenneth Walker's gunfire. If you ever see the crime scene photos outside their apartment, there's blood everywhere. Obviously, an artery was hit. Probably that officer was saved only by the prompt application of a tourniquet. Otherwise, he would have bled out in minutes at best. That officer who was injured, the other officers with him, returned fire, and their fire, one of their rounds, struck Breonna Taylor and killed her. Now, Officer Brett Hankison, one of the four just indicted, and the officer who was tried in state court on felony reckless endangerment charges. He fired into Breonna Taylor's apartment, but it was not any of his rounds that struck Breonna Taylor. In fact, his rounds didn't strike anybody. He was firing in response to his fellow officer being shot by Kenneth Walker. He would testify at a state trial that he believed he saw a threat through a sliding glass door window, through the curtain covering the sliding glass door window, and he fired a number of shots into Breonna Taylor's apartment through that sliding glass door window. So claiming, of course, that he had a subjective belief that doing so, firing those shots, was necessary in the defense of his fellow officers who were being shot at by Kenneth Walker inside the apartment. Now, several of Officer Hankison's rounds penetrated through Taylor's apartment into an adjacent apartment in which there were three people, innocent bystanders present, a man, woman, and a child. And Hankison will be charged under Kentucky law on 3 counts of wanton endangerment based on the danger that his rounds purportedly presented to those 3 people in the adjacent apartment. Now, wanton endangerment is based on recklessness, a mental state of recklessness. Recklessness occurs when you are creating an unjustified risk of death by your conduct and you engage in the conduct anyway. The typical analogy would be driving drunk and then running somebody over and killing them. You never had any intent to kill anybody, to hurt anybody at all. But you know that being drunk and getting behind the wheel creates an unjustified risk of death to others. You did it anyway. Death results. Despite your lack of intent to kill, you're still criminally liable on the basis of recklessness, having knowingly creating a risk of death and ignoring that risk. So that's what the state alleged in Officer Hankison's trial on wanton endangerment. And he would ultimately be acquitted of all charges in a jury trial in state court. This was written about in the website I've already mentioned, Legal Insurrection. For those of you who are law self-defense members, I'll include a link to that article in Legal Insurrection about this acquittal in the blog post version of this at the lawselfdefense.com website. Now, the United States Department of Justice Civil Rights Division is taking its own shot at Hankison, as well as 3 other officers, but again at Hankison, for the same conduct for which he was acquitted in state court. This time claiming not wanton recklessness under Kentucky law, that would be the state charge, but claiming 2 counts of deprivation of rights under color of law. So the federal indictment against Hankison specifies 2 counts of criminal conduct. The first count is based on the Department of Justice claim that Hankison violated the civil rights of Breonna Taylor and Kenneth Walker. Kenneth Walker is Taylor's boyfriend who was firing at police. But the DOJ claims that Officer Hankison violated their civil rights to be free of unreasonable seizure by his conduct of firing into Taylor's apartment. So in essence, the DOJ is arguing that Hankison's firing into the apartment was not justified, was creating an unjustified risk of death to Taylor and Walker. And we all have a right to not be subject to death by police officers under federal law. That's the allegation here in the first count. The second count in the indictment against Hankison is based on the Department of Justice claiming that Hankison violated the civil rights of the 3 people in the adjacent apartment by his conduct of firing the rounds that entered their apartment. Now, remember, he wasn't intentionally shooting into their apartment. He was firing into Breonna Taylor's apartment, essentially at gunfire flashes he saw in Breonna Taylor's apartment. It's, presumably the gunfire being fired at his fellow officers. But Hankison's rounds over-penetrated Taylor's apartment, entered the neighboring apartment where these 3 innocent bystanders were. And the indictment characterizes these rounds as having been fired, quote, after there was no longer a lawful objective justifying the use of deadly force, close quote. Now, that claim is completely contrary to the testimony at state trial by Officer Hankison himself that led to his acquittal in state trial. He claims he was firing at what he believed to be, he would claim what he reasonably perceived to be a deadly force threat against his fellow officers. But nevertheless, this is the federal grand jury indictment claim. Now, both these charges are based on alleged violations of federal code, 18 U.S.C. Section 242. And if Hankison is found guilty of deprivation of civil rights under color of law, meaning as a police officer, under the authority of government, under circumstances in which death results, and of course Taylor died, then he is subject to execution, capital punishment. Now, what are some of the challenges to a federal conviction of Hankison as specified in the indictment? Well, conviction on these charges would require the prosecutors prove beyond a reasonable doubt that Hankison's use of force was not justified as lawful self-defense of himself and of his fellow officers, who were, again, being subject to the gunfire of Kenneth Walker. And this argument's already been made in Kentucky State Court by state prosecutors arguing that his firing into the apartment was not justified, and the state's argument was found lacking before that state court's jury, resulting in Hankison's acquittal in that state prosecution. That said, it's always possible that the federal prosecutors in federal court might have better luck in convincing a federal jury that they have met the high burden necessary to defeat Hankison's claim of justification. You get a different jury, you might get a different result. That's all part of the noise in the system, even though the evidence and really the legal principles being applied are all the same. Again, the consequence for Hankinson, should the federal prosecution be successful in overcoming his legal defense and justification, would potentially be execution, capital punishment. Now let's look at the second officer indicted last week by the federal grand jury in the context of Breonna Taylor's death. This is Detective Kelly Goodlett. This is a female Kentucky police officer, Louisville Metro PD, charged by the Department of Justice in the events surrounding the death of Breonna Taylor. And the DOJ alleges both that she conspired with other officers to falsify the search warrant affidavit for Taylor's apartment. And this is claimed to be a violation of, again, Federal Code 18 U.S.C. 242, subject to capital punishment. And also that she conspired to cover up this conduct after Taylor's death, which is claimed to be a violation of a different U.S. code, several U.S. codes actually, for the cover-up. I'm not going to specify all these in the video. They'll all be in the blog post. If you're a law self-defense member, all these federal code references are hyperlinked in the blog post of today's content, so you can click through and read these codes themselves, just like we're going to link the federal indictments against each of the officers. So what does the indictment actually allege against Kelly Goodlett? First, the indictment alleges that she failed to challenge or object to a purportedly false claim made in the affidavit for the search warrant by others. The search warrant for Taylor's apartment claims that the criminal target of the warrant, the alleged drug dealer J.G., was receiving packages at Taylor's apartment. So for those who don't know, this is how this works. I'm referring to a search warrant. I'm referring to an affidavit. So let me be clear about what's happening. The search warrant itself is a document that's signed by a judge or a magistrate, a judge-like character who signs off on search warrants. But he needs evidence to support probable cause for the search warrant. That evidence comes to the judge in the form of affidavits, sworn documents, typically sworn by police officers, the officers seeking the search warrant. So the officers are making sworn statements in the affidavit. The affidavit is the premise for the judge to sign off on the search warrant, authorizing other officers to go in and conduct the search of the targeted premises. So the allegation by the Department of Justice here is that these officers now indicted lied in the affidavit for the search warrant. And then after Breonna Taylor's death, when this became high profile, they conspired with each other to cover up the lying. So these would be separate offenses under federal law. The first, the lying in the warrant, would be a violation of Section 242, which carries a death penalty. The cover up after the fact doesn't cover the carry the death penalty, but does cover sentences of 20 years. So very substantial. So the federal indictment alleges that Detective Goodlett, not that she lied per se on the affidavit for the search warrant, but that there were things in the search warrant, the indictment claims, that she failed to challenge or object to, that she should have been more critical. This is the basis for the death penalty. Folks, does it seem somewhat ambiguous to you that she wasn't firm enough in challenging things in an affidavit written by a fellow officer? Second, the indictment against Goodlett alleges that she falsely asserted in the affidavit for the search warrant that other detectives had verified. And when I do the scare quotes on video, folks, that's because the scare quotes are used in the indictment, which makes me wonder why. Why not just use the word verified? Why put verified in quotes? Because normally when you put a technical term of art in quotes, what you're trying to suggest is you don't mean it literally. You mean it figuratively. But of course, criminal law is very literal. So the fact that they put scare quotes around verified suggests to me that they don't actually have evidence of any kind of verification. They're just trying to suggest or imply some kind of verification. So every time I see these scare quotes in the indictments, that makes me extremely nervous about what it is exactly was supposed to have happened here to subject these officers to execution. A lot of scare quotes in these indictments. So the second allegation in the indictment against Goodlett is that she falsely asserted in the affidavit for the search warrant that other detectives had verified that purported drug dealer JG was using Taylor's apartment as his current home address. Again, those scare quotes are in the indictment. They put quotes around current home address. Why? What are they trying to suggest? That they don't literally mean current home address? That their claims don't literally refer to current home address? This ambiguity in the indictment that carries the possibility of execution bothers me. You'd think before you were prepared to execute a police officer, you'd be pretty damn detailed and specific and concrete about what you're claiming they did wrong. Third, the indictment also claims that in May 2020, so about 2 months after the search warrant was served and Breonna Taylor was killed, that roughly 2 months after the service of the warrant and Taylor's death, Detective Goodlett agreed to meet with another now indicted officer, Joshua Janes. We'll talk about Janes in a moment. And during this meeting, the two conspired to fabricate a false story claiming that yet some third officer, Sergeant J.M., who was not indicted here, but they, according to the indictment, they conspired to fabricate a story that they hadn't been told by a third officer that the drug dealer was receiving packages at Taylor's apartment. And they fabricated this claim of this information from this third officer in order to cover up the purported lies they made in the search warrant. Now, again, there's a lot of ambiguity here. Supposedly, Goodlett and Janes met in Janes' driveway to conspire this cover-up, but both of them, both Goodlett and Janes, are indicted here by the grand jury. So which of them turned state's evidence? There were only two present in the conversation, so how would we even know about this conversation? Were they being surveilled? The indictment doesn't say. The indictment provides no evidence that this conversation ever happened, except for, of course, the summary claim that it happened. How would we know this happened? Based on what? Who told the feds that this conversation occurred? And by the way, the mere fact that the officers met in a driveway, this is being characterized as being kind of inherently duplicitous or negative in some way. Normal cops meet each other in their driveways, at their homes, at coffee shops to talk about cases all the time. So the fact that they're meeting in a driveway, which by the way is a driveway, it's in public, at their homes. You'd think if they were going to meet surreptitiously, they'd meet in a place where you wouldn't expect to find them. But this is being characterized in a way to suggest that the officers were, of course, conspiring. And conspiracy to cover up some prior criminal act is itself a crime. But again, very ambiguous. And of course, the claim that the drug dealer was receiving packages at Breonna Taylor's apartment is intrinsic to the search warrant for the apartment. That's the basis for the search warrant. Fourth, the indictment against Goodlett also alleges that in August 2022, it says here 2020, but I think I made a typo there. I believe it was 2022. So August of this year, in 2020. But now, months after even the alleged conspiracy to cover up the purported lies in the affidavit, that Goodlett falsely told federal investigators that this other police officer, this third police officer, had made a nonchalant comment. The phrase "made a nonchalant comment" is in scare quotes again, folks. That this other officer had made a nonchalant comment that criminal target JG was getting mail or packages, more scare quotes, at Taylor's home. Why all these scare quotes? Do they not mean this literally? And how easy, by the way, folks, would it be to misinterpret a nonchalant comment? Something said as an aside, where someone says, I don't know if someone's receiving packages there. And it's heard as someone's receiving packages there. The I don't know is, there's background noise. Somehow it doesn't happen. So it's a misunderstanding. Are we going to execute a police officer over something that could easily have been simply a misunderstanding? Again, if Goodlett is found guilty of a violation of the cover-up allegations, she's subject to a prison sentence of 20 years. She's found guilty of some violation of another federal code violation for the cover-up, a sentence of 5 years. But again, as with Hankinson, Goodlett is also alleged to have violated 18 U.S.C. 242, and Section 242 carries the death penalty. So she's subject to execution here. Now, what are the challenges to a federal conviction of Detective Goodlett? Well, the biggest challenges appear to me to lay in the ambiguity of these claims of the indictment. All this ambiguity, all these scare quotes, all this unstated evidence. They don't even say they have evidence. It's a vacuum of evidence. Undercuts the proof beyond a reasonable doubt required for a conviction. For example, the indictment claims that Goodlett knew to be false the claim by another indicted officer, Janes, that Goodlett knew that Janes was lying when he said he had verified from a postal inspector that purported drug dealer JG was receiving packages at Taylor's apartment. Now, even if we assume that Janes' claim about this was false, that he fabricated that he'd been told by a postal inspector that the drug dealer target was receiving packages at Taylor's apartment, there's no evidence provided in this indictment that Goodlett knew that claim was false. How would she know it was false? It's reasonable for officers to rely on the claims of fellow officers, especially officers they'd worked with for many years. It would be unreasonable for her to assume that everything she's told by her fellow officers is a deliberate lie. And there's nothing in this indictment that indicates how or why Goodlett was supposed to know that this claim by Janes was false, assuming it was false. We don't even know the claim was false. And Janes claimed that he'd been told by a postal inspector. We'll get to that more when we get to the indictment against Janes. So the indictment against Goodlett then claims that Goodlett had falsely added to the search warrant affidavit that detectives had verified. Again, these scare quotes are in the indictment. What do they mean? That it wasn't verified literally? That it's a figure of speech? But the indictment claims that Goodlett had falsely added to the search warrant affidavit that detectives had verified from databases that criminal target JG was using Taylor's apartment as his current home address. Again, in scare quotes, current home address. Do we not mean that literally? Why does the indictment do this? Now, I note first that all these scare quotes around material claims, very important claims in the indictment, they raise cause for concern in my mind because of the resultant ambiguity. What does verified mean in this context when you put it in scare quotes, when the indictment puts it in scare quotes? What does current home address mean in this indictment when they put it in scare quotes? Why not leave out the scare quotes? Why not speak literally? So if, for example, the purported drug dealer JG had an existing dwelling separate from Taylor's apartment, that was his primary residence, but maybe he was communicating to others in his circle that he was currently staying at her apartment. Yeah, I'm staying with Breonna. And that was overheard. Could this communication reasonably, even if mistakenly, could it be reasonably perceived by law enforcement as verification that purported drug dealer JG was using Taylor's apartment as his current home address? That that's where he was currently dwelling? I don't know, but it's certainly possible. It would be a reasonable interpretation of such a statement, of such circumstances. It certainly doesn't seem the basis for proof beyond a reasonable doubt of intentional lying to violate, deprive somebody of their civil rights to the point where that person, that officer, should be executed. Then we have the alleged count of conspiracy against Goodlett and fellow officer Janes, also indicted here, where they purportedly agreed to falsely claim that another Louisville Metro PD officer had told them in January 2020, so months before the search warrant was served in March 2020, that this other officer, not indicted here, had told them in January 2020 that the criminal target was receiving packages at Taylor's apartment. Now, This other officer who supposedly told them that the drug dealer was receiving packages at Taylor's apartment, he would later tell investigators, no, I never told them that the drug dealer was receiving packages there. I told them I didn't know if he was receiving packages there. Not that he wasn't, because how would anyone know for a fact not, right? Unless you're surveilling the home 24 hours a day, you don't know what packages are being delivered. You might know that you don't know. And the evidence is that this third officer, he didn't tell them there were no packages being delivered for the drug dealer. He said, I don't know if there are packages being delivered. And again, if you hear the sentence, I don't know that the drug dealer is receiving packages at Taylor's apartment, but for some reason you don't hear the I don't know part, all you would actually have heard would be that the drug dealer is receiving packages at Taylor's apartment. Is it hard to understand how that kind of miscommunication could occur in a nonchalant conversation? It certainly isn't hard for me to understand. And again, these claims are made entirely in the absence of evidence. So none of this is documented. None of this is stuff that's written down. So this kind of miscommunication I'm suggesting would be much more difficult if it had been written down or sent via email or made concrete, right? But verbal communication is highly prone to miscommunication. So there's no actual evidence presented in the indictment about any of this. There's no indication that either Goodlett or Janes concedes to this purported conspiracy. They're not saying, yes, we conspired, of course, naturally. And there's no indicated source of other evidence of surveillance, of a recording, of a third party at the scene who might have turned state's evidence. There's no indication in the indictment of any other source of evidence, not even presented in an anonymous fashion, like a normal, reliable informant tells us that there's no evidence showing this purported conspiracy. Is all of this merely speculation on the part of the prosecutors that they heard the two officers met in the driveway and they're speculating that they must have conspired to cover up? Because if the grand jury was presented with evidence, it's certainly not included in the indictment. And of course, all this evidence will ultimately have to be shared with the officers as part of the discovery process in a prosecution. So it's not like the officers aren't going to learn about it anyway. And then finally, we have the counts based on the purportedly false statements of Detective Goodlett and Janes that this other sergeant had said in passing is in scare quotes, folks, that this other sergeant had said in passing or in a nonchalant comment, more scare quotes, that the drug dealer target, JG, was getting mail or Amazon packages at Taylor's apartment. Again, why all these scare quotes around in passing, nonchalant comment, mail or Amazon packages? What's the purpose of all this? Why this ambiguity? Why not just be explicit when you're charging police officers with capital offenses? So all of this, the manner in which this communication is being described suggests purely informal verbal communication, meaning the form of communication most likely to involve misunderstanding. There's no indication of any documentation of any of this communication, documentation that would necessarily make all of these claims concrete and non-ambiguous. Is a comment made in passing or in a nonchalant comment, or the denial of a comment made in such an informal, verbal fashion, that's sufficient to prove criminal guilt beyond a reasonable doubt, especially on a capital charge? I mean, color me skeptical. All right, so that's Detective Goodlett. Now let's look at the next two officers for our purposes, officers 3 and 4 of this discussion. They were both indicted together in a third federal grand jury indictment. These are Detective Joshua Janes, who supposedly met with Goodlett in her driveway to conspire a cover-up, and Sergeant Kyle Meany. So these are two additional Kentucky Louisville Metro PD officers. Again, they didn't serve the warrant on Taylor. They didn't fire shots at Taylor. They were not present, but they were involved in the preparation of the warrant that was served on Taylor's apartment. So they were associated with the warrants. And they were also indicted last Thursday by the Department of Justice, Merrick Garland's Department of Justice. Attorney General Merrick Garland. And these are Detective Joshua Janes and Sergeant Kyle Meany, M-E-A-N-Y. Both were charged under this single indictment. And it alleges that Janes and Meany together, it charges them together and includes counts. Some counts are directed at both ends, some at one or the other. So it gets a little confusing. I'm not sure why they didn't have separate indictments for them as they did for Goodlett, but nevertheless, there's claims that Janes and Meany wrote out and approved, respectively, the search warrant directed at Taylor's apartment. So they wrote out the affidavit, really, for the search warrant. And of course, the officers write out the search warrant as well, but it's signed by a judge, approved by a judge, that they wrote out the search warrant to be signed by the judge, knowing it to be false, that there were false claims in the search warrant. So specifically, the search warrant approved for Taylor's apartment, the indictment says, was based on affidavits sworn by Janes and Meany, and the indictment claims that both officers knew the affidavit contained false, misleading, and out-of-date information, that the affidavit omitted material information, and that the officers knew that they lacked probable cause for the warrants. Further, the indictment of these two officers alleges that the officers knew the search warrants would be executed by armed police officers, thus creating a dangerous situation for anyone on the premises subject to search. Now, that last part's not a legal problem per se. It's not a crime to know the search warrants would be executed by armed police, creating danger to others. That's inherent to service of a warrant by armed officers. It's stated here only because if the officers lied in the warrant, they lied knowing that this would be the result, this creation of risk, which goes to recklessness, as I've already mentioned, the knowing creation of an unjustified risk of death and doing it anyway. That's the mental state of recklessness that can be the basis for a criminal charge. Of course, it presumes that it was an unjustified creation of risk. In other words, it presumes that the officers knowingly lied in the affidavit for the search warrant and or for the search warrant. And again, this alleged conduct is the basis for an indictment under deprivation of rights, under color of law, under 18 U.S.C. Section 242, which carries the death penalty as a punishment. So in terms of specific conspiratorial conduct, and count 2 directed specifically at Janes alone, the indictment claims that in April or May 2020, so this is after the March 2020 shooting of Taylor, that Janes attempted to get a fellow officer, this would be the third officer who's not indicted here, Sergeant J.M., to say that he had, prior to the shooting, told Janes that the criminal target, J.G., was receiving packages at Taylor's apartment. And the indictment also claims that Janes wrote in an investigative letter, a building block of the affidavit for the search warrant, that he had verified through JM of LMPD, who contacted the Postal Service, that JG had been receiving packages at Taylor's apartment. That's all in scare quotes, folks. That entire phrase, verified through JM of Louisville Metro PD, who contacted the police service that drug target JG had been receiving packages at. That's all in scare quotes. Why? The indictment further claims that Janes falsely stated in the investigative letter that a search of LEO database CLEAR, that's an acronym, C-L-E-A-R, CLEAR, had verified JG was using Taylor's address as his residence. Now, again, this is in scare quotes. Why? Why put as his residence in scare quotes? Is it because they don't mean that literally? So they're not trying to suggest that Janes literally said Taylor was using the apartment as his residence? They don't mean it in a technical sense? And by the way, what's the evidence here? Because again, Taylor could have an apartment elsewhere that's his primary residence for legal purposes, that's the address that's on his driver's license, but have begun spending substantial time living in Taylor's apartment. That could also be his residence then. So the fact that he might have had a technical residence elsewhere doesn't mean it would be unreasonable to perceive his staying at Taylor's apartment as also making that his residence. That doesn't make that a lie. It makes it a matter of interpretation. It makes it ambiguous. Ambiguity undercuts proof beyond a reasonable doubt, especially in a capital charge. So the indictment here also references the alleged meeting between Janes and Kelly Goodlett, already mentioned, in which the two purportedly orchestrated a false story, a cover-up, claiming that LMPD officer JM had informed them that the criminal target JG gets Amazon or mail packages at Taylor's home. Again, more scare quotes. Finally, the indictment alleges that this same false claim, this purportedly false claim, was in 2020 repeated to investigators from the Louisville Metro PD Public Integrity Unit. I presume that's their internal affairs unit that investigates officers, as well as repeating this purported lie to investigators from the Kentucky Office of the Attorney General. And then in June 2022, repeated this claimed lie to agents of the FBI. So here we have a real problem, folks. It may not be a crime to lie to state law enforcement, but it's a felony to lie to federal law enforcement. So that's why they're making this allegation here, because it makes it felony conduct, if you believe that these officers lied to the FBI. Now, I will note that the claimed lie to the FBI occurred in June 2022. So the FBI was coming back around 2.25 years after Taylor's death to question these officers again. So was this simply a perjury trap effort by the FBI? We'll interview them, and then we'll make a claim that they lied about what they told us, and now we have a felony charge against them? It wouldn't be the first time a perjury trap was set up by the FBI. So all of this conspiratorial conduct, the basis for count 2 of the indictment, it violates specific federal codes. One is section 1519, that's good for 20 years in prison. One is section 1512, good for 20 years in prison. One is section 371, good for 5 years in prison. But of course, the violation of section 242 by itself is already good for execution. The third count in the indictment against Janes essentially consists of lying to the agents of the FBI. That's another violation of section 1519, good for 20 years in prison. And finally, the fourth count of this indictment is directed towards Sergeant Kyle Meany, and it alleges he made false statements to the FBI, specifically that he falsely told the FBI that the request for a no-knock search warrant, and this was a no-knock search warrant, although the officers serving the warrant say they knocked. And adjacent residents in other apartments say they heard the officers knocking, announcing their presence. But this wasn't a no-knock warrant, and the indictment claims that Sergeant Kyle Meany falsely told the FBI that the reason he asked for a no-knock was because the SWAT unit that would be serving the warrant asked for a no-knock. The SWAT unit says they didn't ask for a no-knock, and so the indictment characterizes this claim by the sergeant as a lie. And this itself is claimed to be in violation of yet another U.S. Code, section 1001, and that's good for 5 years in prison. So what are the challenges now to the federal conviction of Detective Janes and Sergeant Meany under this third indictment? Well, as with Goodlett, the biggest challenges to conviction of either Meany or Janes on these counts appears to me to lay in the ambiguity of the claims of the indictment. Again, all such ambiguity, all these scare quotes, undercuts the proof beyond a reasonable doubt required for conviction. For example, with respect to count 1, which is directed at both Janes and Meany, that they deprived deprivation of rights under color of law. This is the section 242 violation. This is the capital punishment violation, punishable by execution on these facts, because Taylor died in the course of the alleged deprivation of rights under color of law. This capital count, simply summarily alleges that both men knew at the time that the affidavit contained false and misleading statements, omitted material information, relied on stale information, and was not supported by probable cause. What evidence does the indictment share of any of this? Nothing. The indictment provides not even a hint of evidence with respect to those claims, other than the summary claim itself. So how do you know they lied? How do you know they did any of this? How do you know that at the time the officers swore the affidavit, not maybe months earlier, where they might have believed there was inadequate grounds, inadequate probable cause for a search warrant, Because, of course, the evidence in support of a search warrant develops over time. Initially, there may not be enough evidence. So in January 2020, the officers might have said, no, we don't have enough evidence for probable cause for a search warrant. But by March, maybe they had that evidence. So if you only look at what they were saying 3 months earlier in January, where they were saying they don't have enough probable cause for a search warrant, that doesn't mean they didn't have enough probable cause for a search warrant 3 months later in March 2020 when they swore out the affidavit. And the indictment leaves all this ambiguous. It makes reference to January 2020 as if that were controlling on an affidavit sworn out in March 2020, but it's not. So the indictment presents no evidence for any of this. Let's take a look at the next count in this indictment against the two officers. Conspiracy by Janes, alleging 3 violations of federal statutes, good for 20 years, 5 years, respectively, alleging that Jane falsely claimed another officer, Sergeant J.M., not indicted here, had informed him that the criminal target, J.G., was receiving packages at Taylor's apartment, and Sergeant J.M. denies having made this representation to Janes. So the indictment presents it as a lie by Janes. Specifically, Sergeant J.M. claims now that he didn't know whether or not J.G. was receiving packages at Taylor's apartment. Well, can we see the ambiguity there? There's a difference between being told by a fellow officer, I know that guy's not getting packages there, and turning that into he's getting packages there. And a fellow officer saying, I just don't know if he's getting packages there. That's not inconsistent with the reality where the packages are being received by the drug dealer at Taylor's apartment. That's ambiguous. It's not a negative contrary statement. In any case, this kind of informal verbal communication claimed by Janes to have occurred in January 2020, months prior to the service of the search warrant, is precisely the kind that is prone to ambiguity, reasonable error, mistaken recall. And once again, there's no documentation of any of this communication. None of this was written down, which would, of course, have made it much more concrete, less ambiguous, less subject to perfectly understandable communication error. For example, might Detective Janes have heard from a different source other than fellow officer Sergeant J.M. that J.G. was receiving packages at Taylor's apartment? So that his fellow sergeant told him, I don't know if she's getting packages. And then a different source said, yes, he is getting packages. And the detective, just over the course of months, simply mistakenly recalls where he'd heard that the packages were being received. He mistakenly attributes that statement to Sergeant J.M. It doesn't mean that Detective Jane didn't receive that statement, that purported claim of fact that the drug dealer was receiving packages at the apartment. It doesn't mean that he's lying about that information. It just means maybe that he misattributed the information to the wrong person, who, of course, naturally denies having made that representation. But that by itself doesn't mean that Detective Jane lied in presenting that information in the affidavit for the search warrant. Certainly not unambiguously enough to support his execution. So we have explanations consistent with innocence for how we could have arrived at this place, how we could have Sergeant J.M. saying, I never told him he was receiving packages, and Jane claiming that, oh yeah, I think it was nonchalant conversation with Sergeant J.M. I think it was him who told me about the packages being received. We have an explanation consistent with innocence for that. And if you have an explanation consistent with innocence, you don't have proof beyond a reasonable doubt. Then the indictment also claims that Janes included in his investigative letter, so a building block for the affidavit for the search warrant, a misleading claim. Misleading. Can we get more ambiguous than misleading? What's that mean? A misleading claim that a detective was able to, and this is in scare quotes, was able to verify through CLEAR, a law enforcement database that as of February 2020, so a month before or weeks before the shooting of Taylor, that the purported drug dealer was using Taylor's apartment as his residence. The indictment then claims that this claim is demonstrably misleading because JG did not live at Taylor's apartment. So now the indictment is saying, well, purported drug dealer JG wasn't living at Taylor's apartment. So we know he wasn't receiving packages there. Does that make sense to you? Is it impossible to understand how someone might not live someplace but still receive packages there? That they might have a different primary residence, but have their drug dealing packages sent to Breonna Taylor's apartment regardless, because maybe they think their primary residence is under surveillance for packages? Does the fact that JG was not living at Breonna Taylor's apartment mean that he could not have been receiving packages at Breonna Taylor's apartment? Obviously not. I mean, this is inane reasoning in this indictment. Again, I remind all of you, as grounds for a charge that carries execution as a punishment. So it's all, again, very ambiguous. JG might have had a primary dwelling elsewhere than Taylor's apartment and also have spent substantial time at Taylor's apartment, so that he was, quote unquote, residing there, residing in both places. The indictment also claims that a postal inspector, presumably an employee of the United States Postal Service, had announced months after the service of the search warrant and the death of Taylor that criminal target JG had not received packages at Taylor's address. So months later, the indictment says, well, we talked to a postal inspector months after this event, and the postal inspector said that packages were not being received at Taylor's address. Even assuming this is verifiably correct, for delivery of United States Postal Service packages, how exactly would the USPS postal inspector have personal knowledge about whether purported drug dealer JG was receiving packages delivered by alternative means, such as Federal Express or personal delivery? These kinds of deliveries by non-USPS means would be fully relevant for the purposes of the search warrant, even if they were not being delivered by the U.S. Postal Service. Now, it's notable that the indictment here does not assert that it's demonstrably the case that purported drug dealer JG never received packages at Taylor's apartment, delivered by any means, whatever. The indictment itself is not saying that JG never got packages there by any means. They're only saying here that the postal inspector is saying that packages weren't delivered to JG at Taylor's apartment, but presumably the postal inspector would only know about USPS packages. Why is the indictment not saying we know that no packages were delivered by any means definitively? Because so long as there are alternative means by which packages could have been delivered to JG at Taylor's apartment, then it's possible JG was receiving packages at Taylor's apartment, even if they weren't being delivered by the U.S. Postal Service. So the postal inspector could be telling the truth, but that doesn't mean that packages weren't being received by other means, by JG at Taylor's apartment. And if they were, the affidavits are not lying on that point. So similarly, count 3 of this indictment alleges that Janes made false statements to the FBI. But again, the falsity of these statements is based on the same ambiguous premise already covered when we talked about whether Janes was outright lying about criminal target JG receiving packages at Taylor's apartment. It's all nonchalant comments, verbal statements subject to misinterpretation. There's no documentation. There's no concrete evidence on any of this, at least not included in the indictment or referred to in the indictment. There's literally a vacuum of evidence. And that brings us to count 4 of this last indictment, now specifically targeting Sergeant Meany. And it alleges that Meany also made false statements to the FBI. And again, this claim shares the same ambiguity, vulnerabilities as all the other stuff I've talked about here. So the bottom line of my reading of these indictments is that they strike me as profoundly superficial, light in evidence, completely absent in evidence, and ambiguous as the basis for criminal charges as serious as capital offenses to be brought against these law enforcement officers on the facts of this case. Now, I note in passing that the lied to the FBI accounts are apparently all based on interviews conducted by the FBI of these officers only in June of 2022. In other words, just a couple of months ago. More than 2 years after the service of the warrant and the death of Breonna Taylor. Why so long a delay? Is the answer simply political necessity of a fantastically failing Biden presidency that needs to present some kind of win to the public? Some kind of social justice to the public? Now, I try to limit myself to the law generally and use of force law in particular, but I expect that many of you who are more politically oriented will have plenty to say about the political dynamics around these indictments of these officers. All right, folks, that's all I have to say substantively about all this. Again, if you're a law self-defense member, this video will be in blog post form on the law self-defense blog for members. And in that blog, I will include links to the actual indictments, links to all the federal codes I cited here, as well as links to some broader coverage around the state trial of Officer Brett Hankinson, in which he was acquitted of all criminal charges related to the death of Breonna Taylor. And with that said, I will just remind all of you once again that if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill, then you also owe it to yourself and your family to make sure that you are hard to convict by knowing the law, not by knowing legal tricks, by knowing the actual law of self-defense, so you're hard to convict. All right, folks, until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.